Good morning. Welcome to the Michigan Hall of Justice for our second day of our October oral arguments. I will call the first case, People versus Loew. This is a 20-minute grant. You have 2 minutes of a free fire zone, and you may reserve time for rebuttal, but we ask that you keep track of that, and hopefully we do not use it all up. And you may begin when you are ready.
Good morning, and I would appreciate reservation of 3 minutes for rebuttal. May it please the court, at its heart, this case is about access. Access to the thoughts and observations and decisional processes of the central figure in any criminal trial, the trial judge, and whether due process, as embodied in judicial canons, in court rules, and other case law, requires that access to the trial judge and all those important facets of the trial judge's role be given out fairly and openly. And in this particular case, we're here because, without question, defendant appellant Daniel Loew was not afforded fair or open access to the thoughts and observations of the trial judge as the people were. And Daniel Loew, following a trial after which he was convicted and sentenced to a term of imprisonment of 20 years, discovered his lack of access that the prosecutor had during that trial. And that's why we're here today. Now, this court has, of course, asked us to be prepared to address 4 particular issues concerning judicial canons, and it's our position that the first issue that the court asked us to resolve, or to at least be prepared to assist it in resolving, is the issue of judicial communications and whether those particular communications, given ex parte, were substantive or administrative in nature. And our position, as we set forth in our brief, is that these were very clearly substantive and not administrative communications. And as the court indicated, in the order that it filed, in this particular instance, the Court of Appeals concluded they were administrative in nature. And we have a difficult time finding how it reached that conclusion, given that the substance of the communications had to do with not just general processes, but processes that were followed or not followed in this particular law enforcement investigation of Mr. Loew, of the police officers, how they conducted their review of physical evidence, whether there was any sort of medical examination done. The trial judge in this instance saw fit, while the officer who was in charge of the investigation, to make comment to the elected prosecuting attorney, who was supervising, of course, at least indirectly, if not directly, the trial attorney in the case, saw fit to point out to her certain deficiencies that she saw in the law enforcement investigation.
Counsel, I'd love to jump in. I'd love to just skip ahead to whether or not this constituted a due process violation. Obviously, I don't think there's any evidence that the jury knew about the communications. So I'd love if you could just address that more. And then I guess the follow-up to that is, does it have to be a due process violation to get a remedy in this case?
First, as to the question of whether it's a due process violation, we certainly submit that it is. As the court is aware, due process is a difficult concept at times to define, but we know what it includes. It includes the right to a fair trial. It includes the right to an unbiased judge. It includes the right to have the same sort of access that the prosecuting attorney has and the advantages that the prosecuting attorney has. And while there's no particular definition in this instance that we can point to, we do know that due process is embodied in the canons and the court rules, including Court Rule 2.003, and of course the judicial canons concerning ex parte communications and the appearance of impropriety.
So is the main argument then that there was bias? I mean, is that the main sort of hook you're hanging the argument on? Or just sort of the whole trial is tainted because of the messages? I'm just trying to figure out how, showing how the outcome was impacted.
Well, I don't know that we need to prove that the outcome was impacted. I think in some respects, given this court's jurisprudence and given other case law that I think has all been fleshed out in the briefs, it's incumbent upon the prosecution, if anyone, to demonstrate that the trial was not compromised, that the fairness of the trial was not compromised. The reason that the court rules concerning appearance of impropriety and the reason why the judicial canons concerning ex parte communications and the appearance of impropriety exist is because they help to embody the ideas of due process that sometimes are so difficult to actually flesh out and to substantiate. And so our position is that in this instance, the ex parte communications, because they were substantive in nature, yes, do constitute a due process issue and violation. Because those same communications created what I think is clearly an appearance of impropriety that non-lawyers and lawyers alike can see, that's also an issue of due process. So whichever basis this court makes this decision on, there is a due process issue here, whether as a result of the ex parte communications in and of themselves or of the appearance of impropriety that those ex parte communications.
It matters a lot which way we go, does it not? If you're not even claiming that there was any prejudice because of this error, are you?
We're not claiming that there wasn't prejudice. We don't believe at this point that it's incumbent on us to demonstrate there's prejudice, and the record is likely insufficient
If we go under the court rule, I mean, it's clear that this was a violation of the canon, the ex parte communication. But if we go under the court rule, then the harmless error statute in Michigan would apply, would it not?
Harmless error, which statute in particular, Your Honor, is that the 769-29 perhaps?
769.26.
Sorry, 769-26.
Yep.
I don't believe that the harmless error statute in this instance applies, and I did see that in.
So you think this is a structural error, no matter whether it's constitutional, non-constitutional, doesn't matter as far as your argument goes?
We believe it's a constitutional error, and that the prosecution.
Justice Welch was asking you why you believed it was a due process violation, and you sort of glossed over your answer. Are you claiming there was actual bias?
I think there is evidence of bias, but I don't believe that the record in the lower court proceedings is fully developed enough to determine whether there was actual bias. And our point is that under circumstances like this, and because
There a great probability of bias based on the ex parte communication? Is that? I'm
I
trying
think
to
there's
understand how does your claim fit under Caperton, for example?
Well, number one, to answer your first question, I do believe that there's evidence of bias. I do believe that the nature of the communications indicates that the judge had made informed judgments about the prosecution's case.
Is it bias in this case, or does this ex parte communication mean the judge is biased and can't hear any criminal cases?
Oh, it's certainly, well, I can't say anything about the judge's bias, generally speaking, because I only have these communications in the context of this particular case. The evidence in this case, the witnesses
Well,
in this case.
what is the evidence? I guess I'm asking the question about the evidence in this case. What type of bias does it show? Does it show a particular bias against your client, or does it show a bias against all criminal defendants? What type of bias do you believe the evidence shows?
It shows a bias toward law enforcement, in the sense that
Well, then this judge would not be able to handle any criminal cases if we were to agree with your assessment.
at least shows a bias toward law enforcement's conduct in this particular case. So does a comment about a particular officer and how he handled a particular investigation extend to all law enforcement officers? I don't think we can go so far as to say that. And perhaps I misunderstood your question, Justice, but I do believe that the comment made by the judge here does show that in this instance, there was, at the very least, as the Loupton case says that we cited, communication, an ex parte communication that was at least an invitation to improper influence.
And I want to be clear, I'm not trying to justify what the judge did here. It appears to me to be a clear violation of the canon. The question is, what are we to do about it?
The remedy.
Correct. And let me ask you this question. What if the judge had sent the same communication to the county prosecutor after the case was over with, and maybe even after the period for appeal was over with. Would that be evidence of bias, or would that be could that be thought of as concern for the efficient functioning of the criminal justice system of the sort that maybe judges should or could provide input on? In other words, you know, when I was a trial judge, occasionally the prosecutors would inquire, how is the line prosecutor performing in my courtroom? If I answered that question, am I biased because I've provided some input, I suppose, on how an attorney is performing in the court?
Let me make sure I'm clear about one point, and I will get to your question. But when I'm talking about bias, what I'm talking about is a judge taking an opportunity to comment on the investigation during the course of trial at a time when there was still opportunity for there to be a response on the part of the law enforcement officers. I believe, in other words, to rectify what she believed was an issue with the investigation at a time when those law enforcement officers, and by extension the prosecutor who was directing the trial where they were testifying, had the ability to do something about it. That's the issue. So to answer your question, Your Honor, when you're talking about a matter down the road after the appeal period has expired, I think it's a matter of degree. I'm still not sure I would say that is appropriate, given the trial judge's high duty to the people and the duty to avoid the appearance of impropriety. It's the judge's understanding that they are held to a higher standard than the average person. I still don't believe that's appropriate, but whether it's a due process violation, once the trial is over, once the ability to address the perceived problem.
I mean, it's no longer an ex parte conversation pertaining to a pending matter, but it certainly
Right.
shows the judge's concern with the poor performance of the investigation, of an investigation. Your response sort of bleeds into the prejudice question when you said the judge communicated at a time when something could be done to address those concerns. So let me just probe you on that, and I know we're sort of under the prejudice area now, but these were not issues that you had to be sort of clairvoyant to see, right? In other words, the trial judge didn't have any particular, from her vantage point, ability to see things that weren't obvious to everybody who was participating in the trial the entire time. Or am I missing something? Was this like a news flash? That this was a poorly conducted investigation? This is not something that was going to be a topic at the trial?
I'm not sure that it would have been a topic covered to the extent that it ultimately was, Your Honor. Certainly the issue of DNA came up in the opening statement. We believe that there was significant augmentation addressing.
You think the fact that they did the DNA testing on the bath mats that nobody could prove were the ones that were present when the crime was committed, that wasn't going to come up?
I think there's a decent chance it would come up, certainly. But I wasn't there at the trial. Of course, I was not trial counsel. It's something that, to be perfectly honest, if I had been trying the case, I'd like to think I would have spotted that.
Did the prosecutor raise these issues in opening statement before the judge's communication?
Prosecutor raised the issue of DNA in her opening statement prior to the ex parte communications. Yes.
Well, and also the meeting with the aunt and the garbage bag full of mats, and the mats were never taken and shown to the victim. Isn't that all from opening statement?
Much of that did come from opening statement. That's correct.
So it sounds like the judge wasn't providing any new news. She was just reporting what the prosecutor's office already knew it had to deal with in the case. At least that's one way to look at that.
The question is, why did she feel the need to report anything at all?
I'm not defending the judge's conduct. I think it was inappropriate what the judge did here, and I'm sure the judge, if she were here, would acknowledge that. The question is, again, what do we do with what happened in this case? So anyways, I'm just trying to get from you, did the judge provide some particular new insight that aided the prosecution in its handling of the case, that altered the trajectory of this case?
I don't know if that can be proven. I don't know if that can be proven on the record that we have.
Okay, thank you, counsel.
Thank you.
Wasn't there some testimony or some issue that perhaps the closing argument might have been altered based off of the advice and counsel they were getting?
Your Honor, that is something that we pointed out in our brief. And as I just discussed with your colleague a moment ago, certainly the categories of issues were brought up in the opening statement, but we believe there was a material difference between what was brought up in the closing versus what was brought up in the opening. But I can't say that, that the issues about the DNA, about the bath mats were raised for the first time at closing argument. Not that I believe we need to, but to be perfectly candid, we can't. Those issues were brought up by the trial prosecutor during her opening statement, at least in brief. Our concern at the end of the day, and when I say our, I think I can fairly speak for the defense bar paying very close attention to the result in this case, just as defense attorneys, prosecutors, law enforcement officers pay attention to this court's jurisprudence when it comes to Fourth and Fifth Amendment issues, constitutional issues. Law enforcement officers need to know how far they can go in a traffic stop, how far they can go in a custodial interrogation. They need guidance from the courts to be able to carry out their duties under the Constitution appropriately in a way that doesn't infringe upon people's rights.
I mean, counsel, I always just thought, going back to first year of law school, that ex parte is ex parte. You don't do it. You don't have a conversation in an ex parte situation without the other side present. I mean, I like to keep things simple, and I just always thought that this was very basic what you learn in law school.
We certainly agree, but of course, just based on the sheer number of cases, state and federal, cited in the briefings in this appeal, it does come up. It comes up with an unfortunate degree of frequency. I, in my experience, have not seen it come up in this particular context. I believe the fact that it happened while the witness, literally while the witness was on the witness stand, and the judge was sitting a few feet away typing an email to the elected prosecuting attorney. I think that's the part that was so shocking and remains so shocking to those of us on the defense bar. And the thought that I'm trying to express is that we all want to know where's the line to be drawn, because we think this is a case where it's appropriate that a line be drawn. It's appropriate that this court, as Judge Belargin in the trial court did, simply say that this is too far, and here's why it's too far.
The problem is you're talking about line drawing, and I don't mean to interrupt, but as we're getting to the end of your time, I'd like you to answer for us. My big concern about the case is if we draw the line the way you're asking us to draw it, which is essentially that any time, I guess, there's a violation of the judicial canons, we consider it a structural error, which would require automatic reversal without consideration of prejudice, we're going to be having a lot more recusals and a lot more new trials in a lot of different situations. So how do we draw the line you want us to draw without vastly expanding recusals and reversals of criminal cases?
And just to be clear, we certainly don't believe that every judicial canon can give rise to or embodies a principle of due process that would endow a litigant with some sort of substantive right. We're not saying that.
Is it every time there's an ex parte communication?
If there's an ex parte communication of a substantive nature, I believe that would shift the burden to the prosecution to determine that this is no harmless error, that there was no prejudice.
Well, you've already said here you don't think you can show prejudice, I think.
Well, but there's a difference between there's a difference between when we have the burden and when they have the burden, of course. And when the jurisprudence is clear that they have to demonstrate beyond a reasonable doubt that there was no prejudice, that there was no harm done to this defendant under these very critical circumstances in his life, I don't believe they can prove that.
It's
I think it's their job, Your Honor.
Fair enough. You're saying if you win, then we would remand and allow the prosecutor to attempt to meet that burden?
The court certainly would have the discretion to do that, I believe.
Well, wouldn't we have to do that if we found it was a due process constitutional violation?
I believe that the court could simply remand for a new trial.
But we wouldn't even allow the prosecutor to do that. It would be like a new class of structural error where there's not even an effort or an opportunity for the prosecutor to prove
That would be up to the
lack
court,
of
Your Honor.
harmless error.
And if I may, I believe I've just got about a minute left, so I would like to save just a bit of time if that's all right. Thank you.
Good morning. Tim Bothman, representing Myrene Cook, the Allegan County prosecuting attorney and the people of the state of Michigan in this matter. To paraphrase from the federal cases, this is not a judicial disciplinary hearing, and quoting from a federal case. It therefore makes no difference on the appeal whether the trial court violated the canon unless the violation somehow tainted the judgment, which in Michigan means that it worked a miscarriage of justice. That is, there's a different result would be probable. It's more likely than not. And sometimes you kind of have to adjust as you're sitting here. Let me kind of cut to the chase and talk about prejudice. I think everybody agrees that the judge violated the canon by emailing the prosecutor and not disclosing that to the defense. But however you characterize that, and these communications are not, in my opinion, easily characterized. Judge Murray says that they're administrative. Judge Reardon thought that they were substantive. I think it's possible to have communications that are neither, such as a communication even during trial to the prosecutor or the head defender saying, gee, your person did a nice job. Well, and you don't disclose that to the other side. Is that substantive? Is that administrative? Is it kind of neither? Whatever it is, the question becomes, did it affect the judgment? Does it affect the case in any way? And the timing of what occurred here is critical to the inquiry, because if you track the opening statement, the direct examination which occurred prior to the email, where the judge simply said the trooper did a poor investigation, didn't focus on any particular detail. The trooper did a poor investigation. But if that email occurred after the direct examination, and the prosecutor went in detail with the trooper through the Aunt Jane brought you the bath mats at 1:15. They were in a garbage bag. You didn't talk to her. You didn't ask any questions.
Counsel, good morning. I just have a quick question for you. I know we can't get into the head of the judge, but when she sent these emails, what was the intent? Like, what would you argue the purpose of these emails were during the trial? What was the hope that she was trying to accomplish?
What was the judge trying to accomplish?
What would you, I mean, I know you can't surmise. I realize it's a difficult question, but what would the purpose of these emails being sent ultimately be?
Well, I think the purpose was to get an answer to her question. Don't they have detectives on these cases anymore? This was a poor exam. This was a trooper testifying who apparently did the investigation. Don't they have detectives? She was wanting to know, don't they have detectives? But she was not trying to coach anything. That was over. And again, if you look at the examination of the trooper by the prosecutor and the closing argument, you can't say that the prosecutor's closing argument was expanded in any way. It tracks perfectly what the prosecutor did in the direct examination of the trooper and said in an opening statement. And the judge didn't say to the elected prosecutor, you need to tell your prosecutor that they can still go and get a search warrant and look for more bath mats and have them. There was nothing like that. It was just, hey, this was a poor investigation. Don't they have detectives? Now, does that affect the judgment? And not communicated to the trial prosecutor. There's no evidence that anything in this trial would be any different if these communications hadn't occurred. And I think, as Judge Viviano pointed out, there's no question that if the judge had to do it over again, she wouldn't do it. It was a mistake, however you characterize it. And I don't think it's substantive. I'll stand with Judge Murray that it's administrative, but I agree that it's hard to put into a class. But the question is, as the federal cases say, not whether or not a canon was violated. The canons vest no substantive rights. The question is whether or not the judgment was affected, the trial was affected. Did the judge do anything that gave an advantage to the prosecutor by making these comments? And I think the answer to that is no. So again, cutting to the chase and kind of laying aside some of what I plan to say and just focusing in on the prejudice inquiry, I make no mistake here. Our principal concern is with the conviction and avoiding putting the victim through another trial, not protecting the judge. I'm not here to represent the judge, but the people of the state of Michigan in trying to affirm the conviction. If the court determines that the trial judiciary should be informed that, number one, any kind of a violation of the canon is something you shouldn't do, and of course you shouldn't do that. If it was administrative, it should have been disclosed. The canon requires that. If the court wants to say, hey, you ought to do that, and you better not come close to the line, this comes close to the line, we think you should avoid this. Even if you want to say it was a substantive communication, nonetheless, you have to determine whether or not it affected the judgment, and it didn't affect the judgment. There are structural rules of recusal. Actual bias of the judge, and there's no evidence the judge was actually biased by asking these questions, or the Caperton test about whether the probability of bias is so great that it can't be countenanced. And even Caperton says that's a rare situation, not any violation of the canon. And the federal courts have held time and time again that a violation of the federal recusal rule by a judge, in other words, a situation where the judge's impartiality could reasonably be questioned, which means that under the federal test that a well-informed, objective person would be led to believe that there was a substantial doubt that justice could be delivered by this judge. A violation of that provision can be harmless error. The court has said that time and time again, and the federal rule, of course, is similar to our rule that any defect or error or irregularity that does not affect substantial rights has to be disregarded.
I'm wondering why can't sort of the level of familiarity and communications in the middle of a trial with a prosecutor who is, I presume, a friend of the judge, and they're communicating during the trial, why can't that show evidence of some sort of bias?
I mean, I think it shows no moral level of bias, and again, I'm not defending that the judge should have made these comments, but it shows no moral level of bias than people walking into courtrooms, including this courtroom, and having a notion from what judges have done before where they're coming from. Or I'm sure that a judge could be on a bowling team with somebody who appears before them. And somebody could say, oh, are they biased? They look at their friends. They bowl together. They play pickleball. They're in a book club together. But judges are not, you're cloistered.
Oh, sure, no doubt about that.
You're cloistered enough.
Right, exactly. But obviously the issue here is the ex parte
So if you
contact.
could say, well, this shows familiarity, well, it may be likely that in many cases the litigants come in knowing there's familiarity. It doesn't. Does it affect the judgment? And the task of the court under the statute is to determine whether it worked a miscarriage of justice. I can't, if I leave nothing else here today, I want to say that it's not appropriate, in my opinion, for the court to send messages to the bench by reversing convictions. You do that through JTC referrals and the Michigan Judicial Institute if they need to put on seminars and discuss these matters. But that's how you send messages to judges, not by reversing convictions. And some of the cases that I have cited in my brief say precisely that the canons don't vest a right. The violation of the canon isn't the question. The question is whether or not the judgment was affected. And if the judgment wasn't affected, if substantial rights weren't implicated, weren't compromised, then whatever we do with the judge, we don't reverse the conviction. And that's what you have here. Again, if you look at the timing of what happened and look at what the judge said, which was, again, simply in what I would use the principal comment, this was a poor investigation, don't they have detectives anymore? If you look at that and the timing of it after the opening statement, after the direct examination where the prosecutor went, again, into great detail with you didn't do this, you didn't do this, you didn't do this, you didn't do this. There's nothing in the closing argument that suggests that the prosecutor did anything other than go over what the prosecutor had done in direct examination. So,
Counsel, I had another question about MCL 769.26, which sets that verdicts can be set aside if there's a miscarriage of justice. That statute specifically talks about the grounds for doing that. It talks about misdirection of the jury, improper admission of evidence, or error for pleading or procedure. So I'm wondering, how does this even fit under that analysis?
Well, it would be, I think, an error of procedure. The trial is the proceeding, and there was an error in the proceeding in that the judge communicated to one side without disclosing that to the other side. So that's the error. And then we want to ask, what effect did that error have in this case? Did it work a miscarriage of justice? And if you look again at the timing and what the judge said, and the judge didn't say, the prosecutor did a poor job on direct, you need to have him ask these other questions on redirect. None of that kind of thing happened. So if the court wishes to, as I say, send a message, it should do so in a different fashion. It could say so in an opinion, but it shouldn't reverse the conviction. This victim shouldn't be put through another trial unless it can be said that a miscarriage of justice was worked. And in our view, if you look at what was said and the timing of it, that just can't be said.
Can you address, you mentioned that we shouldn't send a message by reversing the judgment in this case, which of course is important, but as I discussed with opposing counsel, our concern is if we were to reverse and treat this as a structural error, what would the world look like for the next 1,000 cases when there are violations of the canons that arguably show that somebody has a viewpoint, as you suggested, either in a civil matter favoring one side or the other in civil cases, or in criminal cases where frequently judges come either from the prosecutor's office or under the current administration, more from the defense bar, so that people come to these jobs, as you suggested, with a perspective and an experience, professional experience. What would the world look like if we started to treat all of these issues as a structural error?
Yep, precisely, and that's why it is not treated as a structural error in the federal system. The first prong of the inquiry is demonstrating that there's a violation of the recusal statute federally, and then you go to harmless error. But you have to first demonstrate that the partiality of the judge could reasonably be questioned, and then you go to harmless error. You don't just reverse. And again, the courts have said time and time again, that's not enough. We have to make the inquiry. And I know I can't pronounce it right, the Liljeburg case that this court cited in its order from the United States Supreme Court, that was a case of an actual conflict of interest. The judge's defense was, I forgot about it. I didn't remember that I was on the board with the university that we had discussed this matter, which if you read the opinion, it was clear that the majority was highly skeptical of the judge saying that. But she had an actual conflict, and the court didn't say, hey, okay, automatic reversal, structural error, you went on to harmless error. Now, they did reverse in that case because of the nature of the error. But you don't automatically reverse. You have to make the inquiry. In Michigan, it's under 769.26. And in this case, looking at what, again, the opening, the direct examination and the closing, you can't say that this trial was affected in any way by what the judge did. Thank you very much.
With the little time I have left, I simply want to address the issue of what I would call perhaps a slippery slope of beginning to endow substantive rights for violations of judicial canons. This is a situation where Judicial Canon 2 has been subsumed and is embodied in Michigan Court Rule 2.003. We're not simply talking about creation of substantive rights as a result of piggybacking onto violations or alleged violations of judicial canons. We're talking about a court rule that has embodied one of those very canons, and I believe that's substantively different. Thank you.
Counsel, actually, I have a quick question. Sorry.
I'll take the extra time.
Yes,
Gladly.
absolutely. So 769.26, do you agree with Brother Counsel that this case could involve an error for pleading or procedure?
No. The statute, by its own terms, addresses error in pleading and procedure, and it clearly categorizes the situations on which a judgment or verdict shall be set aside or reversed or not be reversed. Counsel's position is that this is a matter of this is a matter simply of pleading or procedure, and I don't believe it's either. I don't believe this fits. I believe we've already gone over in fairly great detail the distinction between procedure and substance, and we're talking about the latter here. So I believe that we're outside the scope of 769.26. I understand why counsel would attempt to reframe the argument around this statute. I simply don't think it fits. Thank you.
I've got one follow-up, sorry. Because on rebuttal, you focused on the court rule. Touch on a little bit what you think the word warranted means and what impact that has here. Because to me, it doesn't say that they must disqualify themselves.
When I reference 2.003?
Yeah.
Okay.
Says a disqualification of a judge is warranted if the judge engages in behavior giving the appearance of impropriety.
Warranted as opposed to the mandatory
Mandatory.
language of shall disclose. I believe in these circumstances, disqualification is warranted, of course, and I believe that if we were set out at the beginning of trial or at the time that this particular ex parte communication was discovered, that we believe is in violation of not only Canon 3 but Canon 2, if that had been disclosed to opposing counsel, to defense counsel at the time, it's inconceivable to me that attorney would not have immediately requested some sort of relief, up to and including a mistrial. If that had been disclosed to him after, say, on a break in testimony, that while that law enforcement officer was testifying, the trial judge sitting next to him was emailing the elected county prosecutor, I believe that disqualification is warranted under those circumstances, and I believe that it would have been asked for or a mistrial requested if it had actually been aired to defense approximately or immediately after it happened. Does that help?
Yes, thank you.
Well, I'm just trying to understand what rule you're asking us to adopt and how that rule is going to impact future cases. So I suppose your argument is, you'll take relief wherever you can get it, but you're asking us to find this as a structural error, is that right?
Yes.
That because it's a violation of a canon, or because it's a violation of a court rule, or because it's a constitutional violation, or some witch's brew of all three?
No one ever wants to call their argument a witch's brew, of course. But certainly, as I tried perhaps insufficiently at the beginning of my argument, principles of due process for a criminal defendant are built into those rules and canons that we're talking about.
When you talk about due process, your client received notice and a hearing before an impartial decision maker, did he not?
You said he received notice.
He had a
and hearing
trial. He had notice of the charges. He had a trial before a jury of his peers. And you're not here claiming any particular decision the judge made was tainted by some type of bias. I mean, that's the problem I have with your argument. If we conclude that the judge here was biased, so biased based on this ex parte communication that she's not an impartial decision maker, and number one, she can't hear any criminal cases, and any of us that go to any organization that advocates for one side or the other of the law and accepts awards and participates in functions or comes from a certain background will all be tainted. And so who will be left to decide cases? That's the problem I have. So don't you have to show us that this judge was not an impartial decision maker in order to get to the point where you have approved a due process violation?
I believe the appearance that she was an impartial decision maker is sufficient under the circumstances.
So this case is like this is another Caperton. This is on the same level as Caperton. Is that what you're saying? The appearance is as strong as the rare case of Caperton. They said that was a really rare case. This just happens to be another one, and it's right there alongside of it.
This is an extremely rare case, and I think we should all be thankful for that. But it is hard. The contexts are completely different. But certainly, in terms of the appearance, in terms of the extent to which they think this can call into question the fairness of the system, to people who are going to trial in this county and other counties in Michigan, I believe it does rise to that level of importance, Your Honor. Yes, and it is a difficult thing to conceptualize. There is no specific rule out. No one ever imagined we'd have to create a rule that says the trial judge can't email the prosecuting attorney during trial about a witness testifying at that trial. But we all have to just make do with the rules and the canons and the case law as we have it. And I believe that there is room, without radical action on the part of this court, to redress the issue, the problem, the violation of the Constitution that happened here.
All right, thank you, counsel.
Thank you.
Thank you both. The case will be submitted.